Well, it's time to try a trust hypothetical. For those of you taking the bar in California, remember that California tests majority law in trusts. It does not test California trust law, with the exception of some of the provisions like omitted spouse, omitted child, and the definition of lapse, anti-lapse in California. So this is majority law, and if you're taking the bar in California and you see a call that does not say answer according to California law, then it's not wills, it may be trusts. We see here requests made by Kate, Bill, and alma mater, and we're asked how the court should rule. So I'm going to look above to see if I can figure out what they're asking for to know what the subject is. It says Bill and alma mater now request a court order terminating the trust. Well, I know that if they're beneficiaries, the only way they can compel termination of the trust is if they're all competent and they all consent, and no purpose of the trust is frustrated by terminating it. So I don't know what's in the hypothetical, but we will find out. That's only Bill and alma mater, who are lender and Kate. I'm looking up above and I see Bill now requests a court order directing Tom to invade the trust principal. And I know that when I see that kind of a request or a demand in a trust hypothetical, it may be a spendthrift trust. So Kate requests a court order directing Tom to pay all future installments of trust income to her rather than Bill until some sort of arrearages are eliminated. I don't know what that's about. I've got to start at the top and figure out what's going on with this trust. Lender requests a court order directing Tom to pay all future installments of trust income to it rather than Bill until some kind of a judgment is satisfied. All right, all kinds of court requests for court orders compelling the trustee to behave in a certain way. So what do we have in the hypothetical? And yeah, this is unusual because most of the hypothetical is the terms of the trust. It says in 2003, Sam executed a valid testamentary trust, and the terms of the trust state, and it gives 4 provisions. A testamentary trust. In a testamentary trust, the material provisions of the trust have to be in the will itself. And here we have them, 4 provisions. It names Tom as trustee, and the first provision is that all net income is to be paid to Bill, Sam's nephew, for life. So Bill is the life income beneficiary. The B provision says Tom may invade principal for Bill in such amounts as Tom, in his sole and absolute discretion, determines. So this is, so far, sounds like it's probably a support trust. But then we see the trust terminates on Bill's death, and any remaining principal is to be distributed to Alma Mater University. And the 4th provision tells us it's a spendthrift trust because it says the interests of the beneficiaries are inalienable and not subject to the claims of creditors. That makes this a spendthrift trust. And we know that Bill is the life income beneficiary. We know that alma mater is the remainder beneficiary, the remainderman. So before we go back to those calls, let's take a look at what we know about spendthrift trusts. So the hallmark of a spendthrift trust is that the trustee is restrained from transferring raise to creditors. The beneficiary is restrained from transferring his or her interest and support. Income can't be transferred to creditors until it's been paid to the beneficiary. After it's paid, on petition to the court, a creditor can ask for a judgment against the beneficiary, but creditors can't reach the raise on a spendthrift trust until it has been received. And there are exceptions to that, and you see the exceptions here. Payment of contracts for necessaries. That's stuff like food, clothing, shelter, the necessities of life. Payment of alimony and child support is an exception to that inability to reach into the raise of the trust. A tort judgment is another one. And of course, debts to the government. So that's in essence the core of what we need to know about a spendthrift trust. And as I said, that fourth provision is what tells you this is a spendthrift trust, because it says the interests of the beneficiaries are inalienable and are not subject to claims of creditors. All right, I know it says that Sam executed a valid testamentary trust, but I'm still going to form this trust. I'm going to talk about the elements needed to form a valid trust, because we're going to need to think about the beneficiaries and what the raise is and what the purpose of the trust is, because we already know somebody wants to terminate it. Okay, so to have a valid trust, to create a trust, you need the intent. And that isn't just, gee, I wish I had a trust. It's the intent to divide legal and equitable title to property, because that's what a trust does. You need a legal purpose. You need a raise, property that's going into that trust. You need a trustee, but no trust will fail for lack of a trustee. The court will appoint one. And you need ascertainable beneficiaries. And as we said, we have ascertainable beneficiaries here. We have Bill as the life income beneficiary, and we have alma mater as the remainderman. And now we see that in 2004, Sam died. In 2005, lender obtained a judgment against Bill for an unpaid credit card bill that includes charges for tuition, groceries, and stereo equipment. Lender now requests a court order directing Tom to pay all future installments of trust income to it rather than Bill until the judgment is satisfied. There we have necessities and some that are not necessities, and they always give you a range, one that clearly is a necessity, one that clearly is not, maybe more than one of each. So remember our rule. Income may not be transferred to creditors until it's been paid to the beneficiary. After it's paid, on petition to the court, a creditor can ask for a judgment against the beneficiary, generally not compel the trustee to pay it directly to them. And creditors cannot reach the raise or a spendthrift trust interest until it's been received. But then there are the exceptions, and that's what they're testing here. One of the exceptions is payment of contracts for necessaries, food, clothing, shelter, etc. Well, food is certainly a necessity. Stereo equipment is certainly not, although some of us would like for it to be. Tuition, that is in that middle area. And to a large extent, courts will find that to be a necessity. And in an increasing minority of jurisdictions, a creditor can compel the trustee to pay the beneficiary's interest directly to them. But the court will not allow the entire support amount to be paid. And states vary in how they define how much of that support payment can go directly to a creditor. because the purpose of the spendthrift trust, of this kind of spendthrift trust, is to support that spendthrift. So the court is not going to wipe out the entire support payment in paying creditors. It will be a percentage. And then we see that Bill is delinquent in making child support payments to Kate, his former spouse, for their child. Kate now requests a court order directing Tom to pay all future installments of trust income to her rather than Bill until the arrearages are eliminated. Well, the court isn't going to do exactly that. It's going to extend the support benefits of that spendthrift trust to Bill's dependents, but it will not allow the corpus of the trust to be exhausted, nor will it totally take away Bill's support. It will, to the extent that it can, meet the child support payments out of Bill's payment. And of course, that payment is discretionary. The trustee can increase that payment, but it will not exhaust the corpus, and it will not leave Bill without support. So now we see that it's tested two of the exceptions to the rule that a creditor cannot reach the raise or the interest of the trust. They can only reach the payment after it's been paid to the beneficiary. What do we have next? Well, now we come to what Bill wants. Bill is the life income beneficiary, and he wants Tom to invade the trust principal so that Bill can promote a newly formed rock band. Tom has refused. Bill now requests a court order directing Tom to invade the trust principal. Can he get that kind of a court order? First, think about it from the trustee's side. That trustee has a fiduciary duty to protect the trust, to protect the raise of the trust. And a beneficiary cannot compel him to invade that raise and can't terminate the trust. Not a spendthrift trust, but that's what he's trying to do. And notice that it's a newly formed rock band. It's something very speculative and not necessary. That's what Bill is asking for. The terms of the trust give Tom the sole discretion to decide what to pay out. So he has the authority to refuse. And I need to establish that authority in my answer, but I need to go way beyond that and talk about his fiduciary duty to protect the raise, because he has a duty to allocate fairly. He cannot favor the income beneficiary over the remainderman. And to pay out large amounts of the trust raise on a risky, unnecessary venture would be unfair to the remainderman. That forms the basis of my analysis here. When you get a spendthrift trust on an exam in an essay, they're going to be going after those exceptions to the rule about not being able to reach the trust raise or the interest in the trust if you're an outside creditor. They're going to be testing multiple exceptions, and that's exactly what they've done here. So then we get to that final paragraph. Because of Tom's refusal to invade the trust principal, and because Alma Mater is concerned over Bill's debt difficulties, Bill and Alma Mater wish to terminate the trust in order to divide the trust principal, but Tom has refused. So they have asked for a court order to terminate the trust. What do we need to know here? We need to know that the trustee has no power to terminate unless the trust purpose is accomplished. It isn't in a spendthrift trust, or as provided in the instrument, and it was not provided for in this instrument. So the trustee doesn't have the power to terminate. Will the court do it? Can the beneficiaries compel it? Well, only if all are competent and they all consent and no purpose of the trust is frustrated by terminating it. Because of the purpose of a spendthrift trust, it's not terminable unless the settlor as well as all beneficiaries agree. Well, we have two beneficiaries here, the life income beneficiary and the remainderment, and they concur. They have shown their agreement by filing for a court order. The problem is that it would frustrate the trust purpose, and that will keep the court from ordering termination of this trust. A spendthrift trust is set up to keep the beneficiary, the life income beneficiary in particular, from squandering all the assets and to protect those assets from creditors. Compelling this trust to be terminated would defeat both purposes. I hope you found that hypothetical quite manageable to do. Wills and trusts hypotheticals are rather like contracts hypotheticals. Just take it one step at a time and complete one piece at a time, and you'll have it. And if you've made it this far in the video, you can do something for me, please. Subscribe to the channel, like the video, share it with anybody you think it would help, and help me get the word out so that more people can benefit from issue spotting these hypotheticals.